On August 16, 1963, an elderly couple stopped to pick some flowers along Rockwood Street in Mount Pleasant, a suburb of Perth, Western Australia, when they discovered a rifle hidden amongst some nearby bushes. They notified the police, who collected the weapon and performed ballistics tests on it. These tests showed that the rifle was the weapon used in the murder of Shirley MacLeod, an 18-year-old student who had been killed by a single shot to her head while she was babysitting at a house on Wavell Road in Dalkeith. The discovery of the rifle was the best lead police had in the case, and they decided to use it to lay a trap for Shirley's killer. Hoping he would come back to retrieve the murder weapon, they replaced it with a different but similar rifle, which had been modified so that it could not be used. They tied the rifle to the bushes using fishing line and set up surveillance. Police spent over 2 weeks watching the bushes from a nearby camouflage tent. On September 1st, just after 1 a.m., a car pulled up near the bushes. The driver exited the vehicle, walked up to the bushes, and reached for the butt of the rifle. The 2 police officers watching from nearby ran out from their hiding spot and wrestled the man to the ground. The man was Edgar Cooke, a 32-year-old father of 7, who was known to police because of several arrests for thefts and burglaries. He initially told the officers who apprehended him that he had come to collect the rifle, but not because he had left it there. He claimed he had seen the weapon in the bushes the previous Thursday and had come back for it. He had been observed driving up near the bushes the previous Thursday without getting out of his car, but was still brought into custody. While in custody, Cooke would ultimately confess to 8 murders and 14 attempted murders. He also admitted to breaking in to over 250 homes in Perth. His crimes varied in mode and method, and all of his crimes were not previously connected due to these differences. His first admitted act of serious violence was in September of 1958, when he ran down a woman riding a bicycle with a stolen car. When asked why he had done this, Cooke replied, "I just wanted to hurt someone, and she was it for the night." While his crimes would remain varied, stealing cars and running down individuals of opportunity would remain one of his preferred acts of violence. Cooke said that he committed his first murder in January of 1959, when he stabbed Penina Berkman to death with a diving knife in her South Perth home. She left behind an 8-year-old son, who had been spending the night with Penina's former landlords, who remained close friends with her and watched her son on nights when she would go out for the evening. Cooke also confessed to one of Australia's most shocking crimes of 1963, a seemingly random spree of shootings around the western suburbs of Perth in the early morning hours of January 27th, just as the country finished celebrating Australia Day. 5 people were shot, 3 of whom did not survive. The then unidentified perpetrator of these various crimes was referred to as the Nightcaller and the Nedlands Monster in various media reports. Cooke was able to provide extremely detailed accounts of his crimes, even remembering the exact denominations of the coins and bills he stole from some of the hundreds of homes he robbed, and new information about several of the crimes he claimed responsibility for that the police had not released to the public. While Cooke's confessions seemingly solved numerous unsolved cases, they also created a major problem, because 2 of the crimes he confessed to were already considered solved, and 2 other men were serving time for committing them. In December of 1959, 22-year-old Gillian Brewer, an heiress to the Robertson family fortune, was killed in a brutal attack with both a tomahawk and a pair of dressmaking scissors in her apartment in Cottesloe. 2 years later, a profoundly deaf and mute man named Darryl Beamish, who had been just 18 years old at the time of the murder, was found guilty of the crime and sentenced to death. Police claimed to have obtained 4 confessions to the murder from Darryl. 2 he gave using sign language through an interpreter. 1 was in a written statement, and another was found written in the exercise yard at the facility where he was being held. Darryl claimed that the confessions had been coerced and were the result of intimidation and assault by police. John Button had spent the day of his 19th birthday with his girlfriend, 17-year-old Rosemary Anderson, in February of 1963. They returned to his parents' home that evening and ate fish and chips while watching television with John's brother Jim. Out of the corner of his eye, John saw a hand reach over to take some of his fish, and, assuming that it was his brother, said to leave it alone. It had not been Jim, but Rosemary, who was annoyed that John was so quick to anger and chastise her over a piece of fish. She walked out of the house to return home, with John following behind her. He drove alongside her as she walked down the street, apologizing and asking her to get in the car and come back to the house with him. She refused and continued walking home. John eventually pulled over and smoked a cigarette, hoping that if he gave Rosemary a few minutes, she would calm down. He began driving down the route Rosemary would take home again, but when Rosemary came back into his view, she was no longer walking. John found her lying unconscious on the side of the road, surrounded by blood. John put Rosemary in the car and drove her to the nearby home of her family doctor, who ran a medical practice adjacent to his home. The doctor called for an ambulance and accompanied Rosemary to the hospital while John waited for the police. When police arrived, John explained to them what had happened. They questioned John about a dent on the front of his car, which he told them was the result of a small accident 3 weeks earlier. He had run into the back of a Ford Prefect, and an accident report on the incident was on file. He then went with the police to show them where he had found Rosemary. He asked the police to take him to the hospital to see Rosemary, but they took him to the police station to question him instead. It was not until he was in the interrogation room that John, who had been focused solely on Rosemary and her condition, realized that the police believed that he had hit Rosemary with his car. The police told him that they knew he had hit Rosemary and asked him to tell them what had really happened. John continued to tell them what had happened that night, and the police grew frustrated. According to John, they punched him in the stomach several times. 5 hours into the interrogation, they informed John that Rosemary had passed away. Intimidated by violence, distraught over Rosemary's death, and wanting the interrogation to be over so he could mourn the loss of his girlfriend, John eventually told the police that he would say whatever they wanted him to say. They gave him a statement claiming responsibility for striking Rosemary with his car, and he signed it. John was charged with willful murder and remanded to the death row wing at Fremantle Prison. During the 3 months he spent there before his trial, he was only allowed to see his parents and his lawyers. When he told his lawyer about the coerced confession, he was told that he would be hanged if he made such allegations against the police in court. John's trial lasted a week, with the confession and the dent on his car serving as major aspects of the prosecution's case. The jury deliberated for just 2 hours. When they announced their verdict, the foreman initially announced that they found John not guilty of both willful murder and the lesser charge of manslaughter, but then realized that he had misspoken and announced that the jury had found John guilty of manslaughter. Being found guilty of manslaughter rather than willful murder spared John from the death penalty, but earned him a sentence of 10 years hard labor. He was assigned to the prison carpentry crew, where Darryl Beamish was also working. A fellow inmate told John that Darryl was also innocent of the crime he was incarcerated for, and John eventually learned enough sign language to be able to communicate with Darryl and try to determine if he really was in the same situation he now found himself in. He eventually learned that Darryl's confessions had also been obtained through intimidation, and was convinced of his innocence. John was approximately 6 months into his sentence when he heard the news of Cooke's confessions, including the ones to the crimes he and Darryl were currently incarcerated for. He told Darryl that he thought their ordeal would be over within a few days. It was not. John's lawyer filed an appeal, but the judge refused to allow Cooke's confession to be used as evidence, arguing that Cooke must have been lying. Darryl Beamish would also appeal his sentence several times in light of this new evidence. Cooke gave evidence at one of these appeal hearings in 1964, but the judge called the account of the murder utterly worthless and dismissed the confession because Cooke was a palpable and unscrupulous liar. Despite confessing to so many crimes, Edgar Cooke was only tried for one, as a single conviction for willful murder could get him the death penalty. He was charged with killing John Sturkey, an 18-year-old Queen Scout who was preparing to move east to accept a scholarship from the Department of Agriculture to study veterinary science. He had been shot once in the head while he slept on the veranda of a student boarding house on Vincent Street in Nedlands during the Australia Day spree. Cooke was convicted and sentenced to death on November 27, 1963. Cooke continued maintaining that he had killed both Rosemary Anderson and Jillian Brewer, right up until his death. 15 minutes prior to his execution, he took the Bible out of the hands of the minister waiting with him and swore on it that he had killed both women. Cooke was hanged at Fremantle Prison on October 26, 1964, becoming the last man to be hanged in Western Australia. Darryl Beamish's death sentence was reduced to life in prison, and he was ultimately released from custody in 1977, having served 15 years. John Button was released on parole after serving 5.5 years of his 10-year sentence. He moved into a small apartment with his parents, who had to sell their house and spend all of their savings to pay for their son's legal fees. While John was no longer incarcerated, his conviction still hung over him, affecting him in terms of his mental health and in very concrete, practical ways. John's time in prison limited his ability to work. In addition, John's mother was eventually diagnosed with cancer, and she and John's father moved to England for treatment. Because of his criminal record, John was unable to visit them there. He applied for an exemption when his mother's health declined so that he could see her one final time, but she passed away before the exemption was approved. In 1992, journalist Estelle Blackburn learned of John Button and Darryl Beamish's cases. She spent the next several years investigating and published a book on the case in 1998 called Broken Lives. The success of the book led to increased media attention on and public interest in the cases. Lawyers, other journalists, and forensic experts took interest in and became involved with the cases, and new evidence was uncovered. All of these combined efforts eventually resulted in John and Darryl being able to file new appeals. John Button's appeal went to court in 2002. The court would not allow Edgar Cooke's confession to the murder as evidence, but it did allow his widow, Sally, to testify to the numerous confessions to Rosemary's murder Cooke had made to her, and permit John's lawyers to use a 1964 affidavit given by Cooke describing how he had hit Rosemary to compare the details Cooke provided with the findings of new accident reconstructions, which were videotaped and shown in court. The new reconstructions were performed by expert Rusty Haight, who found that the impact damage caused by hitting a pedestrian was not present on the Simca John had been driving at the time. 3 vintage Simcas were used in the reconstructions, striking a biomedical human form dummy at varying speeds. None of them showed the damage present on the front of John's Simca that he had attributed to his earlier accident, and all of them had damage to their hoods that was not present on John's Simca. Haight also found that even if Rosemary had been struck with a Simca, she would not have been killed or even sustained serious injury. She also would not have ended up so far off of the road, where new witness testimony confirmed she had landed after being hit. Haight also performed a reconstruction of the events as described in Cooke's affidavit. Cooke claimed that he stole a 1962 Holden that night. He saw Rosemary walking down the road, waited for traffic to clear, and turned the car to line up with her. He struck her at a speed somewhere between 35 and 40 miles per hour, sending her body over the car's hood and roof. One major reason the appeal judges believed Cooke's account to be a fabrication in 1964 was the lack of damage to a metal sun visor that had been present on the Holden. They held that a body could not have been thrown over the vehicle, as Cooke described, without hitting the visor, and that Cooke's account therefore must have been a lie, he told in an attempt to delay his execution. When Haight reconstructed the events as described in Cooke's affidavit, the sun visor did play a role in his findings, but not in the way the judges had assumed it would have almost 40 years earlier. The dummy flew over the car as Cooke had described. It did hit the visor, which caused it to fly further out to the side than it had during the reconstructions with the Simcas, causing it to land at a distance more consistent with where Rosemary's body had been found. The sun visor was slightly distorted, but it sprung easily back into place without so much as its paint cracking, leaving no sign of the impact. Detailed photographs of John Button's Simca were available, but there was no way to examine the car Cooke claimed he used to kill Rosemary, or any of the damage left on it. According to Cooke's affidavit, after running Rosemary down, he drove the stolen vehicle to Kings Park and crashed it into a tree in an effort to disguise the damage Rosemary's body had left on the vehicle. The car's owner was able to verify this fact, testifying that his Holden had been found crashed into a tree in Kings Park that morning. There were no photographs of the crashed car available, only a report from a panel shop that repaired it. However, based on the results of his reconstructions, he was able to testify that John Button's Simca could not have been used in Rosemary's murder, and that the crime could have occurred just as Edgar Cooke had described. Further important testimony at the appeal came from Trevor Condren, the police crash examiner who had inspected John's car after Rosemary's murder. He testified that he had been able to tell that the car was not the one used in the crime, but had been prevented from testifying to that in court. He further testified that there had been no blood, tissue, or fabric fibers found on the Simca. In 2002, the appeals court accepted Cooke as Rosemary Anderson's killer, and John Button's manslaughter conviction was overturned. Western Australia's Court of Criminal Appeal began hearing Darryl Beamish's sixth appeal in October of 2004, on what would have been Gillian Brewer's 67th birthday. His lawyers were allowed to argue this new appeal based on 4 other attacks on women in their homes in the late 1950s and early 1960s. These attacks were later attributed to Cooke in the state parliament. Darryl's lawyers argued that if the jury at the original trial had been made aware of these other attacks committed by someone else, and the similarities they showed to Gillian Brewer's murder, they would have delivered a different verdict. Documents corroborating Cooke's confession to Gillian's murder were also submitted to the court, and 3 of the 4 women testified about their attacks. In April of 2005, Darryl's conviction was overturned. While previous appeals judges had dismissed Cooke's confessions to Gillian's murder as lies, the judges in this appeal accepted his final admission of guilt, writing, "It seems to us that Cooke had no good reason for lying in the course of making the gallows confession," in their judgment. After the decision was announced, Darryl thanked his family, legal team, and friends. He also highlighted the bravery of Cooke's family, in particular his widow Sally and his oldest son Tony, in their efforts to help him. Tony was present in court when the decision was announced and said afterwards that the gap between the law and justice has finally been closed. John Button was also in the courtroom that day to see his friend finally receive justice, as he had 3 years earlier. Darryl Beamish initially resisted efforts by his legal team to get him to ask the government for compensation for his wrongful imprisonment. Ultimately, however, he decided that extra financial security was important for the care of his wife Barbara, whose health was failing. She was also beginning to lose her eyesight, which made it difficult for the couple to communicate, as Darryl relied on sign language. In June of 2011, the Western Australian government awarded him an ex gratia payment of $425,000. John Button also received an ex gratia payment of $460,000 in June of 2003. He now works with the Innocence Project, training law students to work on wrongful conviction cases, and he and his wife Helen have moved to New South Wales to be closer to their grandchildren. Kevin Green graduated from high school in 1976 and entered the Marine Corps, eventually earning a merit promotion to corporal. He was stationed at Tustin Marine Air Corps Helicopter Air Station in California. He married his high school sweetheart, but the marriage did not last long. The couple was preparing to divorce in 1978 when Kevin met a young woman named Diana Diallo at a bar. Kevin and Diana married 6 months later, in March of 1979, the day Kevin's divorce was finalized and while Diana was 3 months pregnant. On September 30th, 1979, Diana was still pregnant, 2 weeks past her due date. Around 1 o'clock that morning, Kevin left their apartment in Tustin, California, to go to the Jack in the Box restaurant across the street to get a hamburger. The restaurant was full, so he decided to go to another location 3 miles away. When Kevin returned to his apartment 40 minutes later, he noticed an unfamiliar African-American man near a dark-colored van in the parking lot. When he walked up to his apartment, Kevin found his kitchen door open. When he went inside, he found his wife in bed, surrounded by so much blood and with such extensive injuries to her head that he initially believed that she had been shot. He called for help, and Diana was rushed to the hospital. When Diana arrived at the hospital, an obstetrician was able to detect fetal heart tones. They did not attempt to deliver the baby because of Diana's critical condition. Doctors determined that she had not been shot, but had suffered blunt force trauma to her head. She had numerous skull fractures, which resulted in severe swelling in her brain. The next day, fetal heart tones could no longer be found, and Diana underwent an emergency C-section. The baby, a girl who was to have been named Chantal Marie, was stillborn. Diana stabilized after 3 days and remained in a coma for a month. While she survived the extensive injuries from her brutal attack, she was left with serious, ongoing complications from the brain damage they caused. She was suffering from amnesia and aphasia, meaning she lost her memories and could not understand speech or verbally communicate. She lost hearing in one ear and her sense of smell. Kevin and Diana moved in with her parents so that they could help with her extensive rehabilitation and so that Diana would not have to return to the apartment where she was attacked. Diana was sitting in the waiting room of a dentist's office when she saw a picture of a baby in a magazine. She pointed to the picture, and then to her stomach. Her mother took this to mean that she was asking if she had once had a baby, and nodded. Diana then pointed to her wedding ring, and then to her forehead, which her mother took to mean that Kevin had been the one who had attacked her. Based on this interpretation, police took Kevin into custody. He was released 5 days later, as Kevin denied being the culprit, and his mother-in-law's assessment of his wife's gestures was not enough to bring the case to trial. Kevin was arrested again 4 months later, after Diana did eventually say that she recovered the memory of her attack, and that it had been her husband who had assaulted her so savagely. She had a memory of her husband growing angry when she refused to have sex with him, and then beating her with his keyring and raping her. This memory did make sense in the context of Kevin and Diana's volatile and sometimes violent relationship. Kevin drank heavily and had hit Diana before, and the couple argued frequently. Kevin had complained to his friends that Diana no longer wanted to have sex in the later months of her pregnancy because she was so uncomfortable carrying the weight of their unborn child. These facts supported Diana's testimony when she was the key prosecution witness at Kevin's 1980 trial. By that time, Diana had worked hard enough during her rehabilitation to be able to speak again, although she still had a speech impediment and had difficulty spelling her own last name in court. Because of her head trauma and initial amnesia, the prosecution brought in a psychiatrist to testify that Diana's testimony was reliable. Kevin's defense team requested to bring in their own independent psychiatrist to evaluate Diana, but the request was denied. There were circumstances that supported Kevin's claims of innocence. When police arrived at the scene, Diana's blood on her pillow had still been bright red, indicating that it was still fresh, and that Kevin had not delayed in calling for help. Neighbors confirmed that Kevin's car was gone during the time the attack must have occurred based on that evidence, and employees at the Jack in the Box confirmed that he had been there. Police also noted that the food Kevin had brought back with him from the restaurant was still warm when they arrived. The jury was convinced by Diana's testimony, however, and found Kevin guilty of second-degree murder for his unborn daughter's death, and attempted murder and assault with a deadly weapon for the attack on Diana on October 2, 1980. On November 7th, he was sentenced to 15 years to life in prison. Kevin and Diana divorced after his conviction. Bitter over being imprisoned for a crime he did not commit, Kevin spent the first several years of his sentence starting fights and dealing drugs within the prison. Eventually, he realized that he would only survive his ordeal if he turned his life around. He eventually got a degree in computers and a job as an office clerk within the prison, and began volunteering for various initiatives at his facility. After several years, he became eligible for parole, but was denied it on at least 4 occasions because he maintained his innocence, which the parole board took as an indication that he had not been rehabilitated because he was not taking responsibility for his actions. In 1979, an unknown assailant dubbed the Bedroom Basher had committed a series of rapes and murders in the Orange County cities of Tustin and Costa Mesa. He targeted women who lived on ground-floor apartments near the highway and would rape and beat them over the head. The possibility that Diana's rape and attack had been committed by the Bedroom Basher had originally been considered because of the similarities to the other cases, but that possibility was dismissed when she eventually identified her husband as her assailant. The victims attributed to the Bedroom Basher are 21-year-old Kimberly Gay Rollins, 31-year-old Marilyn K. Carlton, and 17-year-old Deborah Lynn Sr., all of Costa Mesa, and 24-year-old Deborah Kennedy of Tustin. In early 1996, investigators began looking into the possibility of using the emerging field of DNA comparison to finally solve the series of murders. They petitioned the Orange County Sheriff's Office to run biological evidence from their cases through a new state database of DNA collected from criminals. This effort would eventually match DNA from 6 different crime scenes to one man, Gerald Parker. Gerald Parker had been a Marine stationed at the El Toro Marine Corps Air Station at the time of the Bedroom Basher murders in 1979. His DNA tied him to the 4 Bedroom Basher victims, as well as to the rape of a 24-year-old optometrist in Costa Mesa, but the 3-year statute of limitations for rape had long since passed. His DNA was also a match to one of the samples taken from inside of Diana Green during her rape exam. Parker was in prison for a parole violation tied to his 1980 conviction for the kidnapping and rape of a 13-year-old girl, but when he was finally tied to all of these other crimes, he was just weeks away from being released. When investigators went to speak with him in Avenal State Prison, he initially denied any involvement. However, he eventually confessed to all the crimes his DNA tied him to, as well as to the 1978 murder of 17-year-old Sandra K. Fry in Anaheim. He would stalk his victims and enter their apartments when he knew they were alone. He would hit them over the head and then rape them. In Diana's case, he had used a 2x4 to inflict her extensive injuries. Parker is African American, and at the time of Diana's attack, he was driving a dark-colored van, meaning he could have been the man Kevin Green saw in the parking lot of his apartment complex the night Diana was attacked. Based on Parker's confession and the DNA evidence, investigators and prosecutors worked quickly to get Kevin Green released from prison. A hearing was held on June 20th, 1996, at which Kevin was declared factually innocent. His conviction was overturned, and he left the courtroom a free man. The following day, murder charges were filed against Gerald Parker. He went to trial in October of 1998, accused of 6 counts of murder. Charge number 4 of his indictment was for the death of Chantal Marie Green. He was found guilty, and on January 22, 1999, he was sentenced to death. In October of 1999, Kevin Green was awarded $620,000 by the state of California for his 16 years of wrongful imprisonment. Kevin Green did not fault his ex-wife for testifying that he had been the one who raped and bludgeoned her. There were a lot of people after that who helped her regain her memory in a way that fit their needs, he told reporters after leaving the first day of Parker's trial. He believes her testimony was made in good faith, and that she believes she told the truth, even though her memory may have been the result of outside influence, while her brain injury left her highly suggestible and without her memory. Diana, who went back to using her maiden name of Diello after her divorce from Kevin, accepts that Gerald Parker raped and struck her, but does still stand by her testimony, and believes that she was raped and bludgeoned by her husband first, and then attacked in a similar way by Parker. She has argued in court papers that Gerald Parker's guilt does not prove Kevin Green's innocence. Diana had filed a multi-million-dollar wrongful death lawsuit against Kevin right after he was convicted over the death of their daughter. She won the judgment by default because Kevin was incarcerated. Kevin filed a countersuit after his release to have the original judgment dismissed, but Diana was allowed to refile. The case was settled out of court, with the terms of the settlement not released to the public, in December of 1999. The ongoing legal case did not change Kevin's view of his ex-wife, and he still did not believe that she was at fault. "She was as much of a victim of the system as I was," he said after the case was settled. Kevin went on to become active in the legal community, speaking with the media and presenting on panels about wrongful convictions and other issues facing the criminal justice system.